matter 25 CM 135, State of Wisconsin versus Ronald Anderson. The state appears through District Attorney Kevin or Assistant District Attorney Jose Vila in person. We have actually Amber Sherwood.
Yes, Your Honor, I'd be making a special appearance for Attorney
Amber's
Sherwood.
case, but you're making an appearance filling in for Miss Sherwood. Is she not going to be here? Is this my only case for her today?
She has one more this afternoon. That'll be Joel.
Okay. Yeah. And she was having something going on.
She's got a pretty gnarly respiratory infection.
Oh man. Oh. Are you filling in for her this afternoon too?
That'll be Joel.
Oh, you said with, I thought you said with Joel this afternoon. Okay, Joel will be filling in. Okay, and we have Ron Anderson in person. We're here for a status conference, so you're not going to know exactly what's going on.
But Your Honor, I do.
But you do.
But I do, Your Honor. I did also cover the previous status, so I am also aware of what happened there. Back in January, the court gave us until this date for Mr. Anderson to take the domestic violence class with Dave Hatch. He was unable to procure the funding. That would have been a prerequisite to an offer to settle as a forfeiture. The offer has now changed for him to plead to the crime for costs. I reviewed that with Mr. Anderson. He would be willing to accept that offer, so we would be asking for a plea and sentencing date.
You wish to accept that offer, Mr. Anderson?
Yes, ma'am.
You want to take care of it here today?
Yes, ma'am.
Have you had plenty of time to think about it?
Yes, ma'am.
We are not in victims' rights compliance.
No, Your Honor.
Who's the victim?
Believe it's Crystal Brady. So CB.
Because I don't believe I have a key. I have no idea. I do not have a key. Okay. Well, sometimes she's here, sometimes she's not. I guess she's not going to be here today, so we can't proceed. April 13th at 2:15.
That'll work for Attorney Sherwood.
Okay, we'll see you then. Mr. Kisslinger in the matter 26 CM 05, State of Wisconsin versus David Kisslinger Sr. The state appears through Assistant District Attorney Jose Vila in person. Mr. Kisslinger appears in person with counsel Peter Vu by video conferencing. We're set today in this matter for a status conference. Mr. Vu, can you please update the court?
Obviously, we were fairly recently retained, Your Honor. As such, we have not received discovery or an offer just yet, so I think it makes sense to set another status.
What is an offer that can be presented?
The offer, I thought I emailed it. Apologies if I didn't. The offer is for his client to get a mental health assessment in a domestic violence education course with Mr. Dave Hatch, and it would be plea to cost without the modifier.
Okay.
All right. So the mental health assessment, are you asking with Aurora, or does it matter, whatever provider?
Whatever he
wishes?
does, we just need to see documentation that he completed it.
And then it would be, if he gets those, it's plead to
The
DC
DC without the modifier for
without
costs.
modifier.
Yeah.
For costs. Okay. All right. So I don't know if I have, there's a demand for discovery that was done. I don't know, they do it with some link. So if you have issues with the link, just make sure you contact their office. I think Shannon is their assistant there that is very tech savvy. She can help you through it. So it's to do both of those two things. And
I
so,
didn't really pay attention when he was saying. I couldn't understand. I didn't hear.
yeah, and you can talk to Mr. Vu or Mr. Pangburn about the offer, but what it is, it's you can, yep, it would be to plead to the cost disorderly conduct without the modifier, no domestic abuse modifier attached, as long as you do two things: a mental health assessment that can be with Aurora or any other type of mental health provider, that mental health assessment, and the domestic violence course with Dave Hatch here through the county. Okay.
Okay.
So you can talk to Mr. Vu and talk to him about that, and he'll talk to the state and do whatever. But that's the offer, okay?
Okay, ma'am.
So what I'm gonna do is, I'm gonna do a shorter turnaround for a status, because if you're gonna do those things, I just wanna know so we know where we're gonna go and how much time we're gonna need. And then we'll go from there.
Okay.
Mr. Vu, can you do April 13th at 10 o'clock for a status conference? And Zoom is fine.
I'm in a plea hearing right around that exact same time, so I kind of don't want to book something so close in case that goes long.
11:15.
11:15. 11:15 would work. Yes.
Okay, 11:15 on April 13. All right, you can come get your notice and you'll be free to go. Okay,
Thank you.
thank you.
Come up now.
Yes, yep.
Thank you.
All right. Thank you, Your Honor.
Ms. Fleckner? Yes. Wasn't expecting to fill in. We'll go on the record in the matter 25 CF 151, State of Wisconsin versus Dominique Fleckner. The state appears through Assistant District Attorney Jose Vila in person. Ms. Fleckner appears in person with counsel Emma Hanu. We're set today in this matter for status conference. Ms. Hanu, please update the court.
Thank you, Honor. There was an offer that was presented in this case. Ms. Fleckner has been participating in drug and alcohol treatment through Arbor Place. There was some, just to be blunt about it, there were some technical difficulties in getting the discovery to Ms. Fleckner. I printed it off, put it all on a jump drive for her. It is now physically in her possession. So I'm just asking for one more status to give her time to review that. I imagine this case will possibly resolve.
So what was the agreement, or at least the offer that was presented?
Let me pull it up here, unless ADA Villard is faster than I am. It would be, right now, it would be to plead to count one, the possession of methamphetamine for a withheld sentence, 1 year probation, with the conditions to include cooperation in the ongoing CHIPS case and cost, and dismiss and read in everything else. I think there were also some possible negotiations ADA Viva and I would have about that.
All right, sounds good to me. How far in advance do you need for a status? What are you thinking?
If you have time on that April 13th date, that would work for me. And I believe Ms. Fleckner said it would take her probably about a week to be able to go through all the discovery.
Could do 10 o'clock on April 13th.
That'll work for both of us.
Oh, wait, I sentenced you, no, you don't handle Ron Anderson, Ms. Sherwood handles Ron Anderson. Okay, so if that works for you in the morning, then we're good to go.
Yep.
Okay, we'll see you then.
Perfect.
Mr. Gustafson. We'll go on the record in the matter 25 CF 159, 25 TR 956 and 957, State of Wisconsin versus Eric Gustafson. The state appears through Assistant District Attorney Jose Vila in person. Mr. Gustafson appears in person with counsel Emma Hanu. We're set today in this matter for status conferences. Ms. Hanu, please update the court.
Thank you, Your Honor. Mr. Gustafson, this is an adjourned status conference. He completed treatment through the Veterans Affairs Association in, should go to St. Cloud in Minneapolis. In St. Cloud, as previously discussed, I requested possible copies of 1994 and 2009 conviction from Minnesota. I was able to confirm this morning that there is a very sad clerk intern physically digging through boxes to see if we can get transcripts from those. I am not entirely hopeful, but I would at least like to give her the chance because she's digging through them. So just asking for one final status to give an opportunity to look at collateral attacks.
Yeah, they're both old, but that 94. Ooh.
They sounded hopeful.
Holy. I could do May 11th. You have your pick of anytime 9 to noon.
Would like 10:30 work?
Sure. May 11th at 10:30. We will see you then. Come on and get your notice and you're free to leave. Mr. Marcia, is he in custody?
Yes.
We will go on the record in the matters 25 CF 112, 25 CF 131, 26 CF 18, State of Wisconsin versus Joshua Marcia. The state appears through Assistant District Attorney Jose Vila in person. Mr. Marcia appears by video conferencing in custody in Burnett County Jail. We have his counsel, Emma Hanu, in person. We're set today for status conferences and an initial appearance in 26 CF 18. Ms. Hanu, were you able to go over that criminal complaint with Mr. Marcia?
Yes, Your Honor. In regards to 26 CF 18, we would acknowledge receipt, waive any formal reading, enter a not guilty plea to the misdemeanor count. We would be requesting a preliminary hearing at this time, knowing that it's likely going to be a waiver. So if the court wants to schedule a waiver of preliminary hearing, that would be acceptable to us.
I could do. You're coming. We could do the 10 o'clock on that April 13th. If it is a waiver, if it's not though, please let us know because we need more time.
Absolutely. Yep.
Okay, April 13th at 10 o'clock. All right, thank you. We are adjourned.
Your Honor, I did file a bond modification.
I'll listen, but most likely you'll have a better chance at arguing. Well, I guess it really won't matter, especially if it's a waiver. Go ahead and you can argue.
Yes, Your Honor. In 26 CF 18, Mr. Marcia was assessed a $2,500 additional cash bond after he was released and subsequently put back into custody. In that time, Mr. Marcia has completed one component. He has left to complete of IDIP doing the victim impact panel with Dave Hatch. The final part of that is community service. Obviously, he is unable to complete community service while incarcerated. It is still Mr. Marcia's intent to do that community service as well as get the medical treatment that originally he had requested a bond modification, but was unable to complete due to his next incarceration. So we'd be requesting a modification from $2,500 cash to $250 with a $25,000 signature component.
I'm going to tell you right there, signature components, doesn't matter if I put $1 million, they're worthless to me because no judge is going to go, okay, well, I'm going to now convert it to $1 million cash. It just doesn't happen. So people can ask for through the sky. And to me, it doesn't matter how much money, $1 or nothing on or $1 million on signature. So that one really, that doesn't help the argument. Mr. Vila.
I'm sorry, Your Honor, I'm pulling it up now. My system just defaulted on me. But based off of what Attorney Hanu said, my understanding is that Mr. Dave Hatch would be able to do the victim impact panel with Mr. Marcia here in the jail, provided that he be able to do the funds, and then it just be an argument about the community service requirement at a potential sentencing. With that portion, if that is what defense is partially basing their bond mod on, state does not object. Regarding the reduction of $250 cash, the main consideration here is that the judge was lenient with him previously. He was let go, and then I believe the very next day he went to the bar and got picked up on new charges. So regarding the signature bond, the state would request that judge deny that one. Thank you.
On allegations of a very high BAC, like very shortly after the court did allow him to get out of custody. And if people are not going to follow the court's conditions, why have the conditions? It's just like having the $1 million signature bond. It doesn't matter if you're not going to follow the conditions and do the things. And so we have 2 allegations here of felony bail jumps in 2 separate cases of violating the court's condition of the very condition of why he is in custody with an allegation of an OWI 4th. Granted, there was no allegation of driving in there, which is to his benefit, and that goes on the positive side. However, based upon that, the court is going to deny the bond modification. The community service aspect can be argued again at sentencing, or it can be stated to have occurred after the fact. The treatment part, I don't even know exactly what type of treatment that he is trying to seek. I don't have any inpatient requests. I don't have anything like that. So it's very hard for the court to think that he's going to abide by the court's conditions when he was given a bond modification and very shortly thereafter violated. So the court is denying the bond modification, but we'll hear any other changes that may occur on April 13th. We are adjourned.
Thank you, Your Honor.
Mr. Belial. On the record in the matter 25 CF 150, State of Wisconsin versus Bradley Belial. The state appears through Assistant District Attorney Jose Vila in person. Mr. Belial appears in person with counsel Renee Landgraf. We're set today in this matter for a status conference. Ms. Landgraf, please update the court.
Your Honor, the matter is resolved. We do have a plea questionnaire. I'm not sure what the court has for time today, but it will be a plea to count one with a joint recommendation of probation for a year, followed through with chips.
I do not have the ability to do it today,
Okay.
unfortunately.
And we would like to schedule a plea hearing.
I could do it as early as tomorrow. Or Wednesday, the 15th at 11:30, or the 16th at 10:45.
April 16th,
Yes.
does that work for you?
10:45.
It's a Thursday. Yes.
All right. April 16th at 10:45. We will see you then. And get your notice, and we are adjourned. Thank you.
How are you?
Good, how are you?
Doing wonderful.
Well, I'm glad. You look good.
Thank you. I'm doing great.
I'm really glad to. We will go on the record in the matters 25 CF 89, 26 CF 09, State of Wisconsin versus Timothy Ainley. The state appears through Assistant District Attorney Jose Vila in person. Mr. Ainley appears by video conferencing in custody in Polk County Jail. We have his counsel Zachary Fisher appearing by video conferencing. We have Kate Murtaugh, guardian ad litem, in the 26 CF 09 matter appearing by video. We're set today for on the record in the matter 26 CM 23, State of Wisconsin versus Charles Cadat Jr. The state appears through Assistant District Attorney Jose Vila in person. Mr. Cadat appears in person without counsel. We're set today in this matter for a status conference, but it could be a potential plea. What's happening today? Anyone?
The offer was made last time for the DC for court costs. I believe Mr. Cadat needed time to go over that and consider it. That's what I have.
I accept that.
You accept it and we would be able to proceed? Yes, victims' rights compliance. So you wish to plead guilty to disorderly conduct, is that correct?
Correct.
How old are you?
48?
Can you read, write, and do you understand the English language?
Yes.
Any drugs, alcohol, or medication?
No.
Any mental illnesses or disorders?
No.
Do you understand you would have the right to have a trial? You would have the right to have an attorney represent you, or you can represent yourself, and they would be able to ask questions of the state's witnesses or call witnesses to testify for you. You would be able to testify on your own behalf or remain silent and not have your silence used against you. You would be able to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you would also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all those rights you're giving up here today?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that the state would have to prove on or around January 16, 2026, in a private place in Burnett County, Wisconsin, you engaged in boisterous, unreasonably loud, and otherwise disorderly conduct that tended to provoke a disturbance? Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $1,000 or imprisonment of up to 90 days or both?
Yes.
Do you also understand that there is an agreement here for costs only, but I'm not bound to follow that, meaning I can sentence you to the maximum penalty if I thought it was warranted. Do you understand that?
Yes, I
Do
do.
you still wish to proceed and enter a guilty plea?
Yes,
Are you admitting here today that you in fact did engage in what the state under criminal code would define as disorderly conduct?
yes,
Are you pleading guilty because you are guilty?
yes.
Do you have any questions for the court or for Mr. Vila before we begin or before we continue?
No, I don't.
Has anyone made any threats or any promises to you for you to plead guilty today?
No,
You're doing so freely and intelligently and voluntarily.
yes.
You know what you're doing here today,
Yep,
and you've had
yes,
enough time to think about it.
yes.
As to count one, disorderly conduct, how do you wish to plead?
Guilty?
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of disorderly conduct. A judgment of conviction will be entered today. The other matter will be dismissed and read in. Argument, Mr. Vila.
Thank you, Your Honor. First and foremost, it's a lower level offense. It's a misdemeanor disorderly conduct offense. Given the fact that Mr. Kadat is here taking responsibility for his actions and given the input from the victim that I did receive on this case, I believe court cost is more than appropriate. Thank you.
Thank you. Mr. Kadat, anything you want me to know? Do you want to tell me anything? Do you want to argue anything to the court?
No,
Okay. Well, I'm aware of what happened here. You're aware of what happened here. Your mother's aware of what happened here. Because of not only this case, but another case and all of those things. I'm hoping you're gonna do what you've said and you want to get the alcohol treatment that is not only gonna be beneficial for you personally, but your family, and it'll help rebuild your family connections and those things, and get a job. Those are not things that I can order you to do. Those are things that you have to want to do to improve your life and to improve your family relationship. So I'm hoping that you'll do that. I don't want you to have to be here again. I don't want to have your mother or father or anyone have to be here again. I think the costs are appropriate. I think you did sit some time in jail, didn't you?
a month, yeah.
Yeah, so let me just see. Because you were in custody on January 20th. And you posted on February 11th. No, February 19th. So about a month, yeah. So what I'm gonna do is I'm sentencing you to 25 days in jail. Time served. Sat the time, you might as well, get the credit. Plus then what I'm gonna do is I'm only gonna assess $250 for the DNA surcharge that's mandatory and a little bit of court costs and fees. I'm waiving the rest because of the jail time, okay?
Okay,
Because you sat the time, you got punishment up front, you had time to sit and to think about life and what you did and all of those things. So I think that's appropriate. So that's what I'm gonna do. 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need to order your DNA. So what you're gonna need to do is go to the jail and provide your DNA, and they might have it, they might not. If they don't have it, they'll just swab you. If they do, they'll just send you on your way. You have the right to request it be expunged through a written letter to the Department of Justice, okay? A written letter to the Department of Justice. I don't think that there's anything else that I have to say, Mr. Vila.
I would agree, Your Honor.
Mr. Kadada, anything else you want to add?
no.
Okay, well, then we are adjourned. Good luck. Go do your DNA and you're good to go.
Thank you.
I think you need a